Keehan, Tennessee Investments, and council, looks like we have you for the next couple cases.
That's correct.
We'll start with the first one here, and each side will have 15 minutes to present their argument, and the appellant may reserve up to 5 if you so choose.
Thank you.
You may begin anytime.
Thank you. Good morning, Your Honors. May it please the Court, my name is Rich Klein with McDonough Hopkins on behalf of the plaintiff appellant, Praetorium Secured Fund 1 LP. I'd like to reserve 3 minutes for rebuttal.
Thank you, counsel.
This is a very simple case. I'll give a statement of the case pursuant to Appellate Rule 21. Keehan, Tennessee Investment, which I'll refer to as KTI, and Praetorium entered into a cognovit note for $2.995 million, and that was done in March 4th of 2014. The other defendants, the appellees, signed cognovit guarees. The money was dispersed, and approximately 1 month later, the note was breached. On May 16th, 2014, Praetorium properly obtained a cognovit judgment in Lorain County Court here for $3,516,711.11, which consisted of principal and interest. On May 21st, 2014, the motion to vacate was filed. That issue was fully briefed. The trial court then vacated the judgment on March 4th, 2015. Not one payment has been made on this note, and it was entered in March of 2014. So we are close to 2 years. Not one payment has been made. The motion to vacate alleged very specious arguments as to why the cognovit judgment should not have been entered. I'm going to address each of those alleged offenses later on. The trial court abused its discretion when it granted the motion to vacate, and that decision should be reversed and the cognovit judgment reinstated. Now, as this court is well aware, cognovit notes and judgments are permitted in Ohio. There is no dispute that the operative documents here had the proper warning under the statute and was obtained in a proper court, Lorain County Court of Common Pleas. The 60B motion to vacate was filed, nevertheless, by the defendant appellees. And for a 60B motion, as the court is aware, it must have two things. One, it must be timely filed, which there's no dispute that it was timely filed. It was filed within a week after the judgment was rendered. But secondly, they must demonstrate a meritorious defense. And as the case law suggested, allege operative facts with enough specificity to allow the trial court to decide whether a meritorious defense exists. It's not just simply alleging a meritorious defense, you must demonstrate that one exists. Now, for meritorious defenses, when you're dealing with a cognovit judgment, it's a little bit different because those defenses are going to be extremely limited by the very nature of a cognovit. There are only 4 meritorious defenses that are available in the cognovit context. 1, non-default. 2, improper conduct in obtaining the debtor's signature on the note. 3, deviation from improper procedures in confessing judgment on the note. And then 4, a miscalculation of the amount remaining due on the note. Those are the 4 areas and defenses that a debtor may be able to assert in a 60B on a cognovit case. Now, other than those 4, there's kind of a catch-all, and that is going to be where 1, if it goes to the integrity and the validity of the creation of the note. I'm going to take a look at each of these scenarios. Number 1, non-default. That wasn't alleged. There's no dispute that not 1 penny has been paid back on this note. Number 2, improper conduct in obtaining the debtor's signature on the note. The debtor signed these notes. There's no allegation that they did sign it, that it was somehow forged or something to that nature. But perhaps this is the category in which the defendants assert that their economic duress defense falls. I'll give them the benefit of the doubt, but let's say that that's the category that this economic duress falls. This defense has no merit. These are sophisticated business parties looking to develop a championship golf course and a high-end upscale residential community, 170 acres in Tennessee. Tens of millions of dollars are involved here. This is not a type of case where you're going to have economic duress. They claim this, they signed these notes because the economy, they were having problems with getting financing. Well, poor business decisions based on the defendant's appellees doesn't cause economic duress. It's not duress that was caused by Praetorium. We simply loaned them the money. If they had difficulties finishing the project or getting other loans, then that's their problem. The economic duress, when you're dealing with sophisticated parties, they have to show, if this is even a meritorious defense in this type of case, which I submit that it is not, but even if it is, they have to show these following three factors. One side involuntarily accepted the terms of the note. We loaned them the money, they accepted it, they certainly accepted the money, they had no problem taking the money. That doesn't apply here. Two, the circumstances permitted no alternative. They could get other financing. In fact, as they pled in their brief, they did get other financing, albeit maybe not to the terms that they would have liked, but they did get other financing. There was other options available to them. And three, that the circumstances resulting in this alleged economic duress was not by Praetorium's coercive acts. We certainly didn't coerce them into taking our money. We loaned them the money, they gladly accepted it. There are numerous quotes in my brief, which I won't burden the court with, but potentially taking advantage of another's financial difficulties, provided that you did not create those financial difficulties, is not economic duress. If that was the case, we would not have check cash and payday loans. We would not have pawn shops. These cases, those types of places, that's what they do. Financial difficulties, they provide a service. That's what Praetorium does. So I believe it's preposterous to contend that there's economic duress in a situation like this that would actually rise to a meritorious defense in a App.No case. Number three, whether there's deviation from the proper procedures in confessing a judgment on the note. Once again, perhaps this is where the defendant appellee's abatement claim falls. And as this court is aware, we've got another argument at 11:30 today on another case that deals with some of the same parties, but different claims. That is a App.No, this one here is a App.No case that is dealing with other claims under different loan commitments. So we have different parties, different claims. This is not a case where abatement would even apply, nor has there been any Ohio case to suggest that abatement would be a meritorious defense in a App.No. Lastly, the miscalculation of the amount due on the note. Now, in this situation, the defendant appellees claim that the full amount of the loan was not dispersed. And they can't ascertain what the judgment amount is going to be from the note itself. Well, neither one of those is proper here. First, the full amount was dispersed. In the brief, there's a statement that shows where all the payments go. It wasn't a loan where you're basically giving $2.995 million and it's just, here's the check for that and do what you want. There are certain fees that are associated with that debt. Those are all outlined. They were signed by KTI. They accepted that these are where these monies were going to go. And then after the money is dispersed, then they complain that it's problematic. The
settlement statement
yes.
you attached to your brief in opposition to the motion to vacate, that shows that disbursements were made, but that's not any kind of proof that they were made.
Well, it was signed off.
I mean, his affidavit is signed in May in support of the motion to vacate. This all went through a title company and was escrowed that way, so it was, according to the exhibits.
Yeah, the money.
Why would the title company have a receipt for the disbursement? That would be proof that the disbursement was made.
The statement that is attached to the brief, and that's outlined in a section in the brief, shows that some of this money was going to be paid as fees. Now, the defendant appellees may not see that money because it would have been dispersed directly to this particular broker or this particular agent as a fee for this loan. So in that type of situation, they may not see it. So they may not have they may not have the understanding that it was dispersed, but it was dispersed. They received everything that they were supposed to receive.
I understand that. And I understand, basically, the fees are coming back. Your client's funding the loan and they're getting fees back.
That's correct.
I mean, they may have funded the loan with less than 2.995, and they're given a receipt for the fees or something, but why wouldn't they be able to come up with some type of evidentiary affidavit or something that, hey, I got this guy puts an affidavit, but money wasn't dispersed, it was all dispersed.
Well, I mean, perhaps that would...
It should be easy enough to prove that.
Well, and perhaps that may have been a situation that we would put an affidavit in there, perhaps that should have been done, but nevertheless, it was dispersed. And it kind of goes with there's case law that suggests that it is an abuse of discretion to vacate the entire judgment if there's a dispute as to the amount that may be due. And that case is Sadro versus Hersey. It's a 2011 Franklin County case, which is discussed in detail in my brief. So, Your Honor, to address your situation here, at worst, what the trial court should have done is say, the judgment will stand, but we will have evidence to suggest and find out what the exact amount that is due and owing. But to simply vacate the entire amount when there's no dispute that they received the proceeds that they were to receive and hasn't paid anything back in 2 years, that's an abuse of discretion. The whole point of these cognitive notes and judgments is to stop this. And so that would be the worst case scenario to address Your Honor's concerns, is that they should have had a hearing. But I submit that that's not necessary in this particular case, because the amount of the debt can be ascertained from the note itself. It talks about a minimum interest. It talks about the principal amount that was paid. And so at worst, the trial court should have taken evidence and not vacate the entire judgment. So in conclusion, the trial court abused its discretion by vacating the entire judgment. It acted unreasonably, arbitrarily, granting this motion. There are no valid meritorious defenses that are alleged in this context. They did nothing more, the defendants' appellees, than to throw as many arguments as they can up and see what sticks. And they haven't paid anything. The purpose of cognovas are to stop these types of activities. They did whatever was necessary. They signed whatever was required of them to get the money. And then as soon as they get the money, that's when they start complaining. The court shouldn't allow that type of behavior. The trial court's motion to vacate should be reversed, and the cognova judgment should be reinstated.
Counsel, before you go, the $528,000 fee to Guardian,
Yes.
was that a fee for entering into the loan commitment on the larger loan, or was that for funding the larger loan?
With respect to the Guardian, I don't represent Guardian. And so I don't know what the arrangements necessarily, as we sit here today, about whether they were paid for other loan commitments. But it's my understanding that if it was to be paid out of this $2.995 million, then that would be related to this particular note, because I'm sure that the construction loan and the bridge loan, which we'll talk about in the next half hour, those had their own fees, et cetera, attached to those. So I would assume that this is the only one. But again, I don't represent Guardian. Okay, thank you.
Good morning. Before we begin, I neglected to say it again, and I apologize to Judge Keehan again.
That's all right.
But I want to say it for the purpose, too, of you gentlemen, as well as the fact that we're reporting this, that we're pleased to have Judge Keehan filling in for one of our judges today on this case. He's from the 11th District, and we're happy to have him. So, with that.
Good morning, everyone.
And we arranged all that nice weather for him to come out here to drive all that way,
That was
too.
pretty terrific of you.
It was so nice.
Are you a skier by any chance?
But not today.
Okay, well, you have.
My name is Chuck Kulkowitz. I represent the FLEs in this matter. With me today is Donald Keehan Jr. Pleased that he came to see the court arguments. In our view, well, first of all, the case that we're going to be arguing next is a companion case to this one. And counsel is incorrect when he says that the cognomen notes are only involved in this case. We filed a case that was assigned to Judge John Moraldi, and we attacked the cognomen provisions in the promissory notes and the guarantees. And Judge Moraldi issued a temporary restraining order in that case, preventing Praetorium from exercising the cognomen provisions. So Judge Moraldi saw the merits of the arguments that we raised before him. Judge Bedleski did too in the case that we are arguing right now. As counsel mentioned, the issues were fully briefed. Evidence was submitted by both sides, and it took them almost a year to rule on whether or not the motion to vacate should be granted. During that time, I must presume that he was evaluating the arguments and facts that were presented, and he did not abuse his discretion by vacating the cognomen judgments. Praetorium has to show that he abused his discretion on each defense, and it's failed to do so. We raised, our motion was timely filed. We raised 4 or 5 affirmative defenses that are set forth at length in briefs. 2 of them I'd like to discuss. The first one is the fact that there was a problem with the total amount dispersed. We produced an affidavit from Mr. Keehan indicating that over $800,000 worth of the loan proceeds were not dispersed. And Your Honor, as you mentioned during counsel's argument, they didn't produce any evidence at all to show that the monies were distributed to Guardian, or that monies were distributed to Praetorium, which is also on the schedule. And that glaring omission was probably noticed by Judge Bedleski when he granted the motion to vacate. The second defense I'd like to talk about is the economic duress aspect of the case. First, a movement's burden in a cognomen note case is only to show that it has an affirmative defense. It's not required to show that it's going to prevail on that defense, or even that there are half a dozen facts that show the defense. We've explained in our briefs the fact that economic duress was a critical factor in actually entering into the bridge loan, as it's come to be called. The principal amount that the Keehans needed was $500,000. That $500,000 was needed in order to satisfy the lender, which had noticed a non-judicial sale. In Tennessee, they had non-judicial sales that they do throughout the South, but they issued a non-judicial sale. So Guardian and Praetorium and Diversified Financial all knew and understood that the Keehan's back was up against the wall. So they added on, piled on, added more than, they made the loan amount more than 5 times what the Keehans actually needed. And a lot of those monies were...
Wait a minute, they needed a lot more than that if they were going to get some of these other payments made. They were in a tax foreclosure.
That's true, but
they owed money to Lorain National Bank and First America to the tune of about $1 million. I mean,
The bridge loan was only to get money to pay pay a delay fee to 10-4. The other monies, there was the principal amount was $24,500,000 to take out all the lenders on the golf course, and there was a $3.5 million loan that was supposed to go through, that was for construction purposes to finish the golf course off and begin construction of homes.
Well, I'm
Well, the
just
point of all this-
looking at the closing statement
Sure.
for this bridge loan, and there was an awful lot more money paid for the Keehan benefit than just the fees that you talked about.
The calculation that I have shows that $800,000, over $800,000 worth of the loan was not dispersed. And there was $500,000 that was go to 10-4.
Well, how do you,
I can't address the particulars of
this was escrow, by an escrow agent,
True.
and the escrow statement says they dispersed the money.
The escrow statement doesn't say that they dispersed the money.
Well, this closing statement that your client signed said that it did, that it was.
Well, the monies that were.
It's a closing statement, it's not a, this is what we're gonna do, this is settlement statement.
But Mr. Keehan, who's got personal knowledge of whether the monies were distributed, says that they weren't. So, going to whether the judge
But
used his
how does
discretion.
that affect his liability on the note? He signed a note for 2.95, and the escrow agent agreed to distribute it. If he didn't distribute it the way he was supposed to, he might have a claim against the escrow agent, but he still owes 2.995.
But the amount of, first of all, the amount of the note was 2.9 million. The amount that was distributed was considerably less. The amount of the judgment that was taken was for the full amount of what was supposed to be distributed plus interest. The amount was, because the amount was not distributed, then we have a defense to the note and the guarantees. That goes to the question of whether the trial court erred and abused its discretion by vacating the entire judgment. We can't tell sitting here today, besides the affidavit of DJ Keehan, as to how much was actually distributed or how much is owed. So the judge,
Well,
in
he
his
only
discretion.
claims 860,000 wasn't distributed.
That's
We don't
true.
say we can't tell, because the only thing we know, or the only thing that's being claimed is that there was, of 2.995,
That's within his-
860,000 was dispersed.
That's within his personal knowledge, that's correct. There may be more that wasn't distributed, there may not. But the economic duress defense that we've raised goes to the entirety of the note. So when counsel says that there is nothing to attack the entire amount of the note, he's incorrect. Because if we succeed on an economic duress claim, then the judge is going to have the opportunity to do one of two things: either rule that the entire amount is not owed, or modify the note to such terms as are reasonable.
There was certainly economic duress from TN4, people he needed to take out for the minority condition people. And there was certainly distress, I assume, from the tax foreclosure. What was the economic duress that was put on by Praetorium?
The amount of the note, the amount of the fees, the cognova provisions, the mortgages that they were insisting go on, be taken off of properties that were in the names of the guarantors.
So it's the terms. They weren't favorable terms, is that?
They were not favorable terms, and Praetorium and Guardian as well were fully aware of the non-judicial foreclosure. Not a tax foreclosure, by the way, non-judicial foreclosure. So, in sum, Judge Bedleski did not abuse his discretion in vacating the judgment. He had plenty of information, plenty of valid valid affirmative defenses. We ask respectfully that the judgment be affirmed.
Thank you, counsel.
To address 2 points that was raised. One, the economic duress issue. The terms were not favorable. That sometimes happens. Praetorium is a hard money lender. These are the types of situations that these lenders get involved in. The defendant appellees certainly did not need to sign this note. They're trying to develop a 170-acre, high-end championship golf course and residential community. There are numerous cases in my brief that states taking advantage of another's financial difficulty is not duress. A threat to do what is legally entitled to do is not economic duress. It's not established. Economic duress is not established when one accepts money under the pressure of financial problems, which difficulties are of the person's own making. The economic duress, to sit here and argue that we didn't like the terms, but we're holding our nose and signing it anyway and taking the money, is just not a proper use of an economic duress. This is not the type of parties that should be able to claim economic duress. They took the money, they asked for the money, they knew the terms, they're sophisticated parties, they accepted the terms, and then after they got the money, now they complain. And that's just not proper. The second we talk about is on the refinance summary. The 5 issues that they complain about all deal with description. The payee is lender, guardian advisors, lender, guardian advisors. And I think Your Honor was correct. If there is an issue that that money was not dispersed, it would have been an issue with the title company. None of that money that they're complaining about would have gone to the defendant appellees anyway. It would have gone for these various fees. And if it wasn't paid to us, it was money that was going to be given to us anyway, whether it's here's $97,000 from one hand and then you take it from the other hand. It's just more of an accounting issue. They're not necessarily going to issue these checks. And if the title company says that that's the proper, that these disbursements were made, then they were made. And it was signed by Mr. Keehan, saying that these disbursements were made. Again, they take the money, sign whatever is necessary, put it in front of me, give me the check, now I've got a problem. And that's just not proper. The trial court abuses discretion by accepting some of these as demonstrating meritorious defenses, when they certainly are not meritorious defenses in the cognotic setting. Trial court's motion to vacate should be reversed and the judgment should be reinstated.
Thank you.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as the opinion will be released on our website. Thank you.
Thank you.